One person with 2 jobs and 2 salaries seems highly likely if you are a shift worker. But what about if you're a government official getting 2 salaries from 2 state entities? This is a true story. It happened in the Northwest Province. A woman was working for the municipality there and the National Department of Water and Sanitation at the same time. I'm joined now by Osborne Molatudi, labor law specialist, to discuss the consequences of this double dipping in terms of salaries. Osborne, good afternoon. Welcome to today. Before we speak about the consequences, I mean, how can this be possible? Surely when you're an employer, you employ somebody, you check whether or not they have another place of employment and why they are moving. I mean, what could have gone wrong here to give this particular lady in the Northwest, I understand, she's a woman, she's now been arrested, such an opportunity?
Good afternoon, Braden, and good afternoon to your viewers. I think one, as a starting point, could attribute this alleged double dipping to, amongst others, weak internal background checks at a particular employer. And in this instance, the second department where the lady in question was employed. And this can come as a result of those in the recruitment department being reluctant to conduct the background checks on the basis of perceived restrictions that come about as a result of the POPIA Act. So, the processing of personal information, etc. You'll recall that in the olden days, recruitment agencies and even employers were very aggressive, in terms of asking all sorts of questions, getting you to sign a document. They can even contact the institution directly, get information about you. But since the POPIA came into being, there appears to be some measure of caution, if not reluctance, to really do the same thing as it was done in the past. But I think in this instance, it was simply due to internal background checks.
Yeah, and she did this for 6 months until the Hawks moved in. I understand the municipality had written to the department, the National Department of Water and Sanitation, to say, can you tell us about the employment status of such a person? And then the truth came out. Now she's been arrested. I mean, she's facing these charges, and there could be serious consequences for her.
Yeah, indeed. But I think the principle here from a labor law perspective is whether or not the job applicant is obliged to disclose certain information to a potential new employer. And generally, it is accepted that, yes, that job applicant has to disclose material information that will enable the new employer to make its decision with or without having been asked a direct question. Of course, that is not the end for that particular job applicant. He or she can rely on the Employment Equity Act to say, you can't discriminate against me because I have made certain disclosures and or I have omitted to make certain disclosures. So it's a 50-50 situation. You do, you are damned. You don't, you are damned. So most prudent employers will then make sure that either through their recruitment agencies or themselves, make job applicants to sign a consent form. It's pretty a straightforward document where you actually get the job applicant to agree that there will be background checks performed on him or her, including previous employment, criminal checks, civil checks, qualification checks, etc. And once that is done, then it will be up to that new employer to make sure that that is in fact undertaken before making a decision to employ that person. One wonders why the rush if the consequences at the later stage may be costly, where you have to report the matter, convene a disciplinary hearing preceded by investigation, and in some instances even hire external legal persons to do the investigation and or including the disciplinary inquiry on your behalf. So rather get it right at the first time than embark in a costly exercise at the later stage to address the problem.
And that onus falls on the employer.
Indeed, indeed. The only duty that lies on the job applicants is the duty to disclose material information. But then take an example of someone who wants to join an organization as a finance manager. Even if that finance manager is not asked a direct question about insolvency or related, our court would accept that we had a duty to disclose that at one stage we were declared insolvent and therefore there may be a problem insofar as managing the finance affairs of your potential new employer. So even if there was no specific direct question, one would imagine that under this circumstance there is a duty to disclose. The same would apply to other capacities where the non-disclosure was or will be material to the position in question.
Yeah, now the Hawks have moved in. I mean, she earned these 2 salaries for 6 months, and they have now to prove the charges against her. I mean, knowing this, I mean, when you declare, surely she should have said, listen, I'm still in the process of leaving my job at the municipality. If you offer me this job here, isn't that material information?
It is material, and I mean, although I don't practice in criminal law, we all know by now that the standard to prove a criminal complaint is much higher than in a civil and or in internal disciplinary hearings. I mean, there you must prove beyond reasonable doubt that the employee had every intention to defraud either the old or the new employer. So, as I indicate, it's always prudent that new employers avoid this by making sure that there are specific questions. Tell us about your previous employment. Tell us why did you leave? What were the reasons, etc. So, you know, one would watch this case with interest insofar as the proof of the complaint in relation to the specific employees for fraud.
Yeah, as we conclude, Osborne, I wanted to know what would be the lessons if any employer is listening to this, particularly in the public service?
Strengthen your HR and recruitment departments and make sure that they are well versed with all the relevant legislation applicable to pre-employment checks, as well as the nature of information that needs to be disclosed. Obviously, take into account any perceptions of possible discrimination, for instance, race, gender, sexual orientation, or even age. But that, you know, on their own does not mean that a new employer is precluded from conducting those checks in order to arrive at a fair decision for offering a job to a job applicant.
Yeah, that makes sense. Thank you very much for your time, as usual, and insights here. Always a pleasure having you, Osborne Molatudi, a labour law specialist, talking to us about this matter of a double dipping in salaries by a public servant who's now been arrested in the Northwest.